Hi everyone, and thanks for tuning into Pensions Awareness Week. And today I am joined by James Skehan from Pension Trustee Support Services. James has over 40 years experience in the pensions industry. Hiya James.
Hi, morning.
Good to have you here today. My own name is Olive Ryan. I'm from moneycube.ie. We're a financial advisor, and so today, James, we're going to be talking about pension adjustment orders.
Yes.
But maybe you could just start us off with what exactly is a pension adjustment order and why do we even have them?
Okay, so a pension adjustment order arises when there is a marriage breakdown. So the marriage breakdown can either be as a result of divorce or judicial separation. But it's important to remember it must be one of those two things. Okay. So in other words, the process has to go through the court. Now, I suppose by way of background, we actually had divorce in Ireland before 1937, but the 1937 Constitution did away with it. So there were two attempts to bring divorce in. First of all, in 1986 referendum, there was actually a sizable 2/3 majority to continue with divorce. But then in 1995, a second attempt, there was a very small majority in favour of it, about just over 50%. Mm-hmm. And then the law came in 1996.
Okay, so it's a very legal side of pensions.
Absolutely. I suppose it stems from a number of different pieces of legislation. We have the Family Law Act 1995, and that deals with judicial separation. The 1996 Act deals with divorce. Okay. And then in 2010, there was a further legislation which dealt with civil partners and qualified cohabitants. Yeah. And then the last piece of the jigsaw was the Marriage Act 2015, because since 2015, you can't have a civil partnership anymore because they can get married.
Okay, very good. So I suppose it's becoming more common now that all those laws have changed. It's becoming a more common feature of someone's pension and pension lives.
Yeah, okay, so divorce and separations are happening. If we look at the statistics going back to 2015 from the CSO, there was about 4,300 applications for divorce and about 1,400 for judicial separation. But having said that, I think it's important to bear in mind that not every divorce or separation will result in a pension adjustment order, because the court's initial objective is to try and leave the pension out of the equation and to sort things out without involving the pension. But then realistically, after the house, the pension is probably the second biggest asset that couples have. Yeah. So more and more it's been brought into the equation.
Okay. And so what is who can apply for the pension adjustment order?
Okay, so anybody that's involved in a relationship that's covered by the legislation. So that can be a spouse, it can be a civil partner, a qualified cohabitant, but also it can be applied by an adult on behalf of a dependent child. Okay. So really anybody that has been a link to the relationship can apply.
Okay, very good. So maybe let's talk a bit more about the different types of pension adjustment orders. Can there be differences in what they...
Yeah, there's two, but probably really three different types of adjustment order. There's a retirement order, which deals with the pension fund, a contingent benefit order, which applies to the life cover or the value of the pension fund on death. Okay. And the last one, which is quite an interesting one, it's called the nominal or nil pension adjustment order.
Okay. And how do they work? What would the differences for them be?
Okay, so the retirement deals with the pension fund, and probably the easiest way to outline how it works is to talk about a defined contribution scheme. Okay. So if we take, for instance, say John gets married he joins the pension scheme in 1988 and gets married in 1990. Things don't work out, and in the year 2000 they divorce. Okay. So what we need to establish is two things: the relevant percentage and the relevant period. So the relevant period is the length of time that he was both in the pension scheme and married, and in this case it would be 10 years. So that's the relevant percentage. And then what the court will do is they will decide the relevant percentage. So how much of the pension fund should be allocated to Mary, the ex-spouse. And if that's, say, 50%, then the next step is that the value of the pension fund applicable to those 10 years is worked out. And if that's, say, 100,000, Mary will get 50% or 50,000.
Right, okay, very good.
So that's the pension. And I suppose the other point to bear in mind about the pension is that you can apply for a pension PAO on the date of the judicial separation or divorce, or in fact any date thereafter. Okay. And I think to watch out for is it is possible with a pension adjustment order to vary it in the future.
Right.
And I'll talk about that a bit later.
Okay, yeah, very good, yeah.
So then the contingent benefit order will apply to either the life cover, as in the sum insured, or the value of the pension fund. A key thing here is that has to be applied for within 12 months of the divorce or the judicial separation. And another key point is that cannot be varied in the future.
Okay,
yeah.
Right, okay.
So they're the two, I suppose, main substantive ones, okay? But the nominal or nil one is quite interesting. And the logic behind that is that the relevant percentage is deemed to be 0.001%,
okay,
and the relevant period is 24 hours. So that's why it's also called a nil order, because it means there's no money in the kitty for the ex-spouse.
right.
But crucially, within the nil PAO, there should be a non-compete clause. So as I said earlier, you can come along and vary a retirement order at a later date.
Yeah.
Crucial with a nil order that you put in a non-compete clause so that the ex-spouse cannot come along later and look for money.
Right. Okay.
So-
Okay. Very good.
So again, the wording and the drafting is very important.
It's very important.
Yeah,
Yeah. Absolutely. And you probably would need help in
Absolutely.
organising these. So
Yeah.
so how does it work? Like what should somebody do when they are in
Okay,
that
so
situation?
the first thing that both the member spouse and the non-member spouse, they need to get advice.
Yeah.
Okay, from the very start. Pension adjustment orders are very complicated, so you need advice every step of the way. And probably one of the first pitfalls that can happen is the ex-spouse can look for information in relation to the pension scheme, and certain probably generic information must be given as a right to them.
Okay.
But what they can't get and what they really want to get is how much money is in the fund.
Yeah. Yeah.
Okay, so that can only be got if the member consents.
Okay.
If the member doesn't consent, the non-member, ex-member, will have to go to court to get the court to force it. So ideally, the member should be encouraged to give the information.
Right, very good. Okay, so is there options then for like how you get access to? Is there you mentioned earlier that there's the varying options that you would put in that you might consider. So when you're leaving you're actually getting the benefits,
Yeah,
what
okay.
do you do then?
So basically, what happens is, okay. So first of all, the procedure. The information will be got. The court will make a decision. Okay, and then the PO is served on the trustees. So the trustees can either be the actual trustees of an occupational pension scheme, or in the case of, for instance, a buyout bond or a PRSA, it is the insurance company that's deemed to be the trustees.
Right.
Okay. So the PO is served on them, and once that PO is in place, it will override trustee discretion and it will override the scheme rules. Okay. So then the next, I suppose, decision is what happens with the benefit.
Yeah.
So Mary has her €50,000. What can she do with it? In a lot of cases, probably through apathy and maybe just because of all the pain that is associated with a breakup, the money's simply left there.
Yeah.
Okay. The next option is that Mary can create a separate benefit, but within the scheme, the same scheme as her, as John in this case. Or the third option is to transfer it out, and that can be transferred to her own pension scheme if she has one, to a buyout bond, or to a PRSA.
Okay, and that's something she can do at any point. She doesn't have to wait
Absolutely.
until the retirement age of that benefit.
No.
Okay.
Waiting till retirement benefit becomes payable would mean leaving the entitlement within John's scheme.
Okay. So you're better off to take some action, whatever's appropriate.
My strong advice would be that Mary, or whoever the ex-spouse is, should transfer the money out.
Yeah. Okay.
The difficulty is that if she leaves the money in the scheme, then she's at the mercy of John.
Yeah.
Okay, so any decision that's made by John will affect Mary.
Okay.
And probably the two obvious ones are investment.
Yeah.
So if there's investment choice available under the scheme, John can decide to switch from Fund A to Fund B, and Mary has to go along with him. And then crucially also, John will decide or determine when benefits are going to be taken. And when he takes benefits, that's only when Mary takes benefits.
Okay.
So without question, I would recommend that one, she gets advice, and then two, that by and large, in virtually every case, she should transfer the fund out.
Just so she gets control over it for herself.
Control over it,
herself.
exactly. Yeah.
So I suppose then another question people might have in this situation is, what if spouse A John retires early or even dies, God forbid?
Okay, so it depends on the type of order. So if it's a contingent benefit order and he retires, leaves service or dies, well then obviously the contingent benefit will be paid out in the event of him dying, but if he leaves service then the contingent benefit doesn't apply anymore. Okay. Likewise, if the scheme is discontinued by the employer or the benefits are changed, well then that will impact Mary as well. Right. She has no control over that. Right. So yeah, that's basically what happens. Okay.
So I suppose just to recap on what we were talking about here, the pension adjustment order is something that is in place for people when a partnership or marriage or civil partnership breaks down. There are a number of different ways that it can be put in place, so which can be complicated and determines the circumstances in which money is actually paid out when the time comes to claim that benefit. So we would say to everybody who is in that situation of a marital breakdown, where there is a pension involved, that they should seek advice.
Definitely seek advice, no question. Both parties need their own independent advice, and the general advice is that the non-member spouse, Mary in this case, should transfer the money out into a pension arrangement in her own name. Yeah. One thing to bear in mind, if money is being transferred out, the normal transfer rules apply. Okay. Apart from PRSAs. So for instance, you cannot transfer a personal pension to an occupational pension scheme. But in PRSAs, normally what happens is there's a restriction, a 15-year rule. If you're more than 15 years in an occupational pension scheme, you cannot transfer into a PRSA. Also, you need what's called a certificate of benefit comparison to make sure that the value you're getting in the new contract stands up against what you're leaving behind. Those two conditions don't apply when a PAO is being transferred out. Okay. So that's just an
important thing
distinction.
For people to know. Yeah. And I suppose from an advice point of view, certainly financial advice, but would legal advice be part of that sector as well?
Yeah, you probably need a combination of pension advice and legal advice. What I have found is that the legal/technical departments within the insurance companies tend to be very good at dealing with PAOs and understanding them. Yeah. What you'll find is that unless it's a specialist pension solicitor, they are kind of at sea with pension adjustment orders. They don't really understand how they work, etc. So get advice, but get the right advice. Yeah. Okay. And then I suppose there's a number of, I think, knock-on issues. Although Mary has taken the money out, her fund counts as a retained benefit for John towards his maximum benefits. Okay, right. But it doesn't for Mary. Right. So she can have her own fund threshold plus the designated benefit that she's got from John. Right. Each of them can get up to 200,000 of a tax-free lump sum, which is quite strange. And again, if you're talking about a very large pension fund, and down the road the combined value of the two funds goes over the maximum fund threshold, then the tax that's paid gets shared out between the two of them in proportion. Okay. So there is a lot of nitty-gritty detail that people need to be aware of, particularly if there's large sums involved. And all of those rules you just mentioned there don't apply regardless of what way you set the pension adjustment order up, whichever option you've gone with. Absolutely. Yeah. Yes.
Okay. Yeah. Well, a lot to consider there, and I mean we probably don't have enough time today to go into too much more detail on it. But James, thanks so much for coming here today to talk to us about this really interesting topic, and I really hope that people listening have got a lot of help with this. You know, I'm sure there's plenty of people out there who are going through something like this right now, or have in the past and really don't know what they should have done and might need to look at it again and seek advice.
Look at it again and get advice. And the problem is, because of all the trauma going through a separation or a marital breakdown of some sort, you know, sometimes things like the pension, they're just not looked at closely enough. So definitely get advice. Yeah, brilliant. Okay, well, thanks very much, James, for coming in today. No problem. Glad to.
Thanks for everyone tuning in, and we are talking about pensions all this week. Pensionsawarenessweek.ie if you want to register and look at some more topics that we are talking about throughout the week. Thanks very much, everybody.